Will now be on the record in 2023 TR 1193, State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney appearing for the state. Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket, I believe. Let me double check. This is a ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. Anything else before we proceed? Hearing nothing further, Mr. Regier, is the state ready to proceed?
I'm sorry, I can't hear. I'm sorry, I can't hear. Hello?
You can't hear?
It was going in and out.
Okay, I asked Mr. Regier if he's ready to proceed. Mr. Regier represents the state of Kansas. He is an assistant Butler County attorney. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appear to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is that. Additionally, the motion for discovery, which is somewhat buried in the document, if you'll pardon me for saying so, would appear to request a series of pieces of information from law enforcement. The state's position is that if the defendant is asking for that information, it would be up to him to issue the necessary subpoenas to the Kansas Highway Patrol.
Thank you, Mr. Regier, for reminding me that this case has a little bit of history to it. I've already covered the charging document that brings us here. And that is the uniform notice to appear and complaint filed by the Kansas Highway Patrol, specifically Trooper Cale Collins. And that was again filed March 27, 2023. Then on April 26, 2023, an entry of appearance of counsel representing the defendant was filed by Chris J. Pate of Pate & Paw, LLC. Mr. Paw appeared in person, Mr. Paw appeared, for his client, but the client did not appear on July 5th, 2023, and the matter was set for bench trial for today. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court. Administrative law in the next paragraph. Ministerial offices being incompetent to receive grants of judicial power from legislature. Citing a case, looks like 140 California 1. And stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear. Talking again about an administrative agency. Then tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. The court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, J, beneficiary. The next page talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed. End quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed. Any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records, and he says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days. Or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. And that takes us up to page 4. Then there is a notice of material facts on page 5. Quoting, I, Robinson Tremaine J, a living human being who is addressing the matter in the above mentioned case, hereby request to put this notice of material facts on record with this court regarding victimless crime of case number 2023 TR 1193, questioning the jurisdiction court, end quote, talking about right to trial by jury. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Revocation of signatures on the final page 7. Mentioning that, quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, of 2335 Winding Cove Town, Florida, in the county of the Seminole of the state of Florida, and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road in the state of Kansas by Officer Collins K, March 27, 23, and then signature authorized representative and attorney in fact, declaring under pains of penalty and perjury. So after that document was filed pro se, apparently by the defendant, there was a motion filed August 25, 23. That was a motion filed by attorney Chris J. Pate. Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se. And that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se, so Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Court. You sent one to a PO box in Topeka. You sent one to 201 West Pine, Suite 101 in El Dorado, which is the correct address for the Butler County Clerk. And then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
Someone signed for it yesterday at the Butler County Attorney's Office.
Yes,
Do you have that where you can screen share it or hold it up?
I can, how do I do the screen sharing? 1 second, okay.
Right.
Yes, I can. I actually can. Well, I got a picture I can show you. I'm turning my camera around so you can see the. You need to, I don't know if you can see the tracking number.
I can't see any of it. It's all blurred out, sir.
What would you, is there a way that I can read it to you?
Mr. Regier?
Your Honor, I would object to the introduction of that as an exhibit. Not only have I not been in receipt of any such document, but the defendant has not laid any foundation testimony, nor does it appear from what little I can see of it to include any notarization or signature attesting to its authenticity.
Okay, well, at this time, I'm not going to be able to.
It was signed for by J. Dean. So are you saying that this proof of delivery isn't sufficient enough?
So you're alleging that you have a return receipt from the U.S. Postal Office showing that on Monday, December 12th, the day before hearing, some document was delivered to the county attorney's office and signed by a J. Dean? Is that your proffer?
Tuesday, the 12th, J. Dean signed for it at the attorney's office. And it's the same document that you read. And it was signed for at 11:45 a.m.
This case, 6 months ago, and first appearance was July 5th, roughly 2 months ago. Trial was set July 5th. Even if the county attorney received that document, I don't think anyone could reasonably expect they would have received it in time to gather the information you want, although I suspect most of it will come out in testimony. Now, I'm looking at the discovery and inspection statute, KSA 223212. Upon request, quoting, the prosecuting attorney shall permit the defendant to inspect and copy or photograph, copy, or photograph the following if relevant. 1, written or recorded statements or confessions. Omitting other language. Number 2, results or reports of physical or mental examinations or scientific tests or experiments made in connection with a particular case. 3, recorded testimony of the defendant before a grand jury, and I'm skipping over some of this. 4, memoranda of an oral confession made by the defendant. B1 shall permit the defense to inspect and copy or photograph books, papers, documents, tangible objects, buildings or places, etc. 2, the prosecuting attorney shall provide a summary or written report of what any expert would testify, except provided in subsection G. This section does not require the prosecuting attorney to provide unredacted vehicle identification numbers or personal identifiers. If the defense seeks discovery and inspection under subsection A2, which is the scientific texts and experiments, or subsection B, the defense shall permit the attorney for prosecution to inspect, provide for attorney. Prosecuting attorney and defense shall cooperate in discovery and reach agreement on the time, place, and manner of making the discovery and the inspection permitted. But this was filed or delivered to the county attorney, assuming it was delivered as alleged. There wasn't any efforts by the defense to contact, cooperate, or reach an agreement as to the time and place of discovery.
Well, if the attorney's office.
Hold on, no, let me finish. Discovery, and then we get down here, discovery made under this section must be completed no later than 21 days after arraignment or at such reasonable later time as the court may permit. So arraignment was July 5th, 2023, which would have given the defendant up until July 26th to make his request for discovery. And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. It was not served, and that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial. The court has to decide if that later time was reasonable, and I do not find that it was reasonably served on the county attorney. Apparently less than 24 hours before the trial, and we're not even sure that it made it to the county attorney. We don't have notice to Jared Regier, the prosecutor in this case. So I am at this point going to say that any last minute motion for discovery is denied, and we are prepared to go to trial. Now, I've lost you, Mr. Robinson. Are you still somewhere available?
No,
What are you doing there with your computer?
right now I was looking for a document, but no, I am not available for trial.
Well, we're going to proceed with trial. So please put yourself back in front of the camera. You must follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive opening statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas it was a Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay, or
I'm not a sovereign citizen.
all right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law, regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being. That person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. In referring to an Eighth Circuit Court of Appeals case, United States v. Yagam from 1992, Yagam found similar issues were completely without merit and patently frivolous. It rejected those issues without expending any more of these courts' resources on their discussion. And again, the Supreme Court also referred to a Kansas Supreme Court case from 2019. Quote, our Kansas Supreme Court has recently affirmed the Requena paddle. The court held that the claims of sovereign citizenship are ultimately meritless. Thus, if the defendant's arguments are on appeal, rely on his sovereignship claims, we hold they are meritless. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed. Please call your first witness.
Thank you, Your Honor. The state we called Master Trooper Cale Collins to the stand.
Please raise your right hand, sir. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Please proceed.
Would you please state your name for the record?
Trooper Cale Collins.
And where are you employed?
I am employed with the Kansas Highway Patrol.
And what is your professional title?
I am a state trooper,
Okay. And how long have you worked in that capacity as an officer?
22 years.
Were you on active duty in your professional capacity on March 27th of this year at approximately 8:48 a.m.?
I was.
And where were you at the time?
I was northbound on I-35 highway, which is the Kansas Turnpike at milepost 85 in Butler County, Kansas.
Okay. I would like to talk about I-35 for a moment. Is that a multi-lane highway?
Yes, it is.
And how many lanes?
There are 2 lanes going each direction.
And by each direction, which directions do you mean?
Northbound and southbound.
And are these northbound and southbound lanes separated by a barrier?
Yes, they are.
Okay, and is this and what is this barrier made of generally?
It's made of concrete.
Okay. And were you and at the time, were you in a vehicle or were you on foot?
I was in my vehicle.
Were you moving?
Yes, I was.
Okay. And you may have mentioned this earlier. What direction were you facing?
I was going northbound.
And at the time, were you in the right lane or the left lane?
I was in the right lane.
Could you please describe your surroundings generally for the court?
It's a straight roadway. At one point we did pass a gantry, which is the metal structure they're going to hang the K-tag cameras on. And there's, a few trees and stuff off in the end of the ditch.
Okay. So with that in mind, would you describe this area as a rural open area overall?
Yes, I would.
Okay. And what was the weather like at the time, if you recall?
It was a clear day.
And did any of these features of the location impair your field of vision in any way?
No, they did not.
Okay. Are you familiar with KSA 8-1558?
Yes, I am.
And what does that say about drivers and maximum speed limits?
That the state of Kansas is allowed to set maximum speed limits.
Okay. And are drivers expected to abide by these speed limits?
Yes, they are.
Your Honor, at this time, I respectfully request the court take judicial notice of KSA 8-1558.
The court does take judicial notice of KSA 8-1558.
Trooper, do you consider yourself capable of identifying traffic violations when you see them?
Yes, I do.
Okay. So in addition to your 22 years of experience, do you have any recurring special training or certifications?
Yes, I do. Every 2 years, we recertify on the radar unit. We also have a 40-hour in-service we attend every year. Or
And are you,
continuing education.
Okay. And are you current on your certification and continuing education requirements?
Yes, I am.
So at the time that we already mentioned, did you see any acts that you considered traffic violations?
Yes, I did.
And what did you see?
I observed a black Mercedes gaining on me in the left lane coming up behind me. I was able to check the speed of that vehicle using my stalker radar in the rear same mode. I checked its speed at 92 in a 75-mile-per-hour zone.
Okay. Now, you've already mentioned that you are certified to use stalker radar. Do you use any form of testing to check that that equipment is working?
Yes, I do. I use a 2 tuning forks to check the calibration of the instrument.
Okay. And how often does this checking take place?
It takes place before every shift.
And suppose that it was not working, the stalker radar was not working properly from this test. What would happen then?
It would be immediately taken out of service.
And did you And on the date in question, did you perform the tuning right before your shift on this day?
Yes, I did.
Can you confirm that the Mercedes was specifically clocked by the stalker radar?
Yes, I can.
And how do you know that?
Because it was the only vehicle in the area coming up behind me.
Okay. Now, you already mentioned that you clocked the speed at, I believe it was 92 miles an hour.
Yes, sir.
Okay. And the posted speed limit is 75. So quick mental math, 17 miles an hour difference overall.
Yes, sir.
What happened after you measured the Mercedes speed?
The vehicle passed me on the left. I got behind it, activated my emergency lights, and it pulled to the right shoulder.
And did you pull directly behind the Mercedes when you activated your lights?
Yes, I did.
So, and when it reached the shoulder, did you conduct a traffic stop?
Yes, I did.
And so once you conducted this stop, were you able to identify the driver of the Mercedes?
Yes, I was.
And did you use any special form of identification to do so?
I did. He provided a Florida driver's license.
Do you see the driver of the Mercedes present in the Zoom conference?
Yes, I do. It's the gentleman with the beard, the black shirt, and we'll call them yellowish orange curtains in the background there.
Your Honor, let the record reflect that the witness has identified the defendant.
Record shall so reflect.
Trooper, were you ever able to speak to the defendant yourself?
Yes, I was.
And did you discuss the defendant's speeding?
I explained his speed to him, asked him for his license, and it was I had the whole traffic encounter lasted 5 minutes, so it was very brief.
I see. And do you recall how the defendant responded to you?
Nothing out of the ordinary. He didn't admit to anything. He did not admit to anything.
Okay. And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay, but do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
I'll follow appeal.
All right. Well, if you don't have that appeal filed in 14 days, you still have to pay your fine and costs. If you don't have the fine and costs paid or the appeal made in 14 days, then your license can be suspended and the money owed can go to collections. Is there anything else we need to take up, Mr. Regier?
I do not believe so, Your Honor, although I would like to personally thank Trooper Cale Collins for his appearance here today.
Thank you.
Trooper Collins, thank you. You are excused. And did I